Yes, Mr. Hill.
Lord Forsyth, could we turn to the issue of financial support and the beginnings of what became known as the McFarlane Trust? Could we have on screen, please, SCGV 607_054? This is a letter, when it comes onto the screen, that was written to you by Dr. Lowe from the Glasgow Regional Haemophilia Reference Centre. It is dated the 16th of September 1987. Before I read through it, did you know Dr. Lowe?
I don't think so, no.
It says this: Dear Mr. Forsyth, I have noted your sympathetic interest in the problem of AIDS, which in Scotland, of course, is mainly a problem amongst intravenous drug abusers. If I just pause there, it's a slightly different point to the rest of the letter. Do you know what sympathetic interest he was referring to here?
Well, I guess you need to ask him. I don't know. I mean, I certainly was very concerned about AIDS and doing everything we could to combat it. I mean, it was people who were infected with HIV, as I indicated earlier, were put into the most dreadful state of fear and anxiety, and as to whether it would develop into full-blown AIDS, and also AIDS was just such a horrible way to die, and at that time it was a death sentence. So I certainly was sympathetic to anything that we could do to make well, we couldn't make life easier, but to try and tackle the problem and provide the support that was needed for people who had, for example, been diagnosed as HIV positive, that they had the right support and counselling. I mean, I don't know what he's referring to. He may have been referring to speeches or press reports. I also tried to work quite closely with some of the MPs who we were not of the same party, but we had a common interest. Thinking of Gavin Strang, who was an Edinburgh MP, and the MP for Strathkelvin and Bearsden, Sam Galbraith.
We'll return to the letter. Dr. Lowe wrote this: I wrote to you as Director of the West of Scotland Haemophilia Centre to request your sympathetic interest in the problem of AIDS, which are now faced by Scottish haemophiliacs. As you may be aware, 1,200 people with haemophilia in the United Kingdom have been infected with the AIDS virus as a direct result of treatment with contaminated clotting factor concentrates administered by the National Health Service. 75 of these infected haemophiliacs are in Scotland, and almost half of these attend my centre. 2 years I've been counselling these unfortunate patients and their families. It is apparent to them and to me that they have a major risk of a distressing and premature death in the next few years. The majority are in their teens, 20s and 30s. This is in addition to their chronic problems with physical, mental and social disability through haemophilia itself. With the full backing of the United Kingdom Haemophilia Centre directors, including myself, the Haemophilia Society, on behalf of patients with haemophilia, is campaigning for some recompense from the state to help them cope with the problems of HIV infection. Previous statements by the government that patients will have to take their turn with fighting their way through the courts to prove negligence are, to my mind, unacceptable in a caring society. Many of them will probably be dead by the time any such case reaches the courts, let alone before any settlement is made. Please read the brief statements by the Haemophilia Society which I enclose. The number of cases of infected haemophiliacs will not increase since the products are now heat-treated and appear almost totally safe. We are talking about only a small number of patients in Scotland. The Haemophilia Society requests that the state makes some contribution to help them with their current problems, to provide some life assurance cover for their dependents and mortgage protection for their homes. It seems a reasonable request. I hope that you can agree with this and discuss it with your colleague, Mr. John Moore. Dr. Lowe, first of all, Mr. John Moore was that stage, the Secretary of State for Health. I think it was before the splitting of the department.
Health and Social Security, yeah.
Dr. Lowe goes on in the letter to ask for consideration to be given to central funding by the Scottish Office of Counselling Services for those who have been infected. As he said in his first paragraph, he had been providing such services, but obviously he was not a specialist counsellor. Could we turn to a minute that brought this letter to your attention? It is SCGV 607_051. I say brought it to your attention. We can see that it is sent to the private secretary, your private secretary at the time. Do you know why it is that this letter would have been brought to the attention of your private office? You must have received a great deal of correspondence on various topics.
Can I just look at this?
Yes, but let's have a read through of this first, and then I'll come back to that.
Yeah, okay.
So it's from Mr. Lugton, dated the 6th of October 1987, sent to your private secretary. Dr. Lowe has written to the Minister to express concern about the difficulties of haemophiliacs who have been infected with HIV through contaminated blood products administered by the National Health Service. The Haemophilia Society are about to launch a campaign for special assistance from the government for this group to help them with their health difficulties and to provide life assurance and mortgage protection. Dr. Lowe is concerned also about the costs of counselling patients and their families who attend the West of Scotland Haemophilia Centre and asks for specific funding. There was an earlier round of correspondence on this subject in January this year, when ministers took the line that while the government has the greatest sympathy for haemophiliacs who have been infected with HIV, there is no state scheme to compensate those who unfortunately suffer any adverse effects from their medical treatment. Such a scheme was considered and rejected by an independent commission some time ago, and that compensation may be awarded by the courts where negligence has been proven. In light of a forthcoming campaign by the Haemophilia Society, the Secretary of State for Social Services minuted to the Prime Minister on the 24th of September, a copy is attached, indicated that having re-examined the case compensation, he had concluded that the previous line was right. Any specific arrangements for compensation for haemophiliacs would cost at least £3 million, and it would be logically difficult to distinguish the claim by haemophiliacs from claims of others damaged in the course of their medical treatment. The Prime Minister has noted the minute from the Secretary of State for Social Services without comment, and a draft reply is then attached. So going back to my question, do you know why it was that Dr. Lowe's letter was brought to the attention of your private office?
I guess because he was writing on behalf of society and probably thought that it ought to be drawn to my attention.
Do you remember whether or not this was drawn to your attention?
I don't remember, but I agreed with much of the content of that letter. The response, which is the covering note from Mr. Lugton, I think makes a really important point where he says it would be logically difficult to distinguish the claim by haemophiliacs from claims of others damaged in the course of their medical treatment. I don't know what the sequencing is here, but my own view was that what had happened to the haemophiliacs, but not just the haemophiliacs, the people who had had blood transfusions and who had also had tissue implants or things of that kind, who had then become infected by HIV, it seemed to me it was such a horrendous and exceptional circumstance that a payment should be made. The difficulty was that particularly in the Department of Health, and the advice was, how could we do this without creating a situation where a precedent was established so that anyone who suffered from a genuine medical accident in the health service would be entitled to compensation. My own personal view was that it was distinct, and the impact of the infection was so catastrophic and severe on the individuals and their families concerned that we should find a way around it, and around that particular problem. And so at a later stage, just to get this all clear, so at a later stage, when it was suggested that the Macfarlane Trust could be set up and ex gratia payments made, I welcomed that. But then the argument, which interestingly in Mr. Lugden's note, which he anticipates, then the argument became, oh, well, we need to distinguish between those people who were haemophiliacs and those people who had blood transfusions. And I thought logically there was absolutely no distinction. And fairly and in justice, there was no distinction that could be made. And that I think, was an argument about the costs as much as the argument about creating a precedent for providing compensation where there were medical accidents was driven by cost considerations.
We'll come on to the later distinction that was sought to be drawn and your views on it.
Yeah.
But the views that you've expressed there,
Yeah.
sense that there should be some form of financial recompense, was that a view that you held right from the start?
Yes. It was obvious to me that this was a wholly exceptional and catastrophic thing which had happened to individuals with, and remember, this is 1987, when there was no prospect of a vaccine or cure for HIV and the consequent development of full-blown AIDS. So that was my view, and I think officials were well aware that was my view. But it was not the collective view of the government. And clearly, in order to get to a position where that was the government policy, it was necessary for the Department of Health to change their position, and it was necessary to persuade the Treasury that this was justified and that it was not creating a precedent. I mean, the other thing, which I'm not a lawyer, I'm uniquely advantaged in that respect, so I don't. Apologies to the chair. To me, it was about treating people fairly as much as anything else, and I couldn't see how, if the argument was that people had to go to the courts, something that was touched on in the letter, given the likely prognosis for the people who were affected, and given the time that it takes for the legal process to grind through, it was unlikely to be of benefit to the people concerned. And also, I felt, how would you begin to prove causation if so much of the information about blood donations and who gave them was kept private, and what would the consequence be of unraveling all of that? So my own view from the beginning was that we should find some way of making an ex gratia settlement.
Was that view influenced by any sense that the government, speaking broadly, had done something wrong in the way that it had provided blood and blood products? Or was it just a moral view that the government should help this unfortunate set of people regardless of what had happened before? Yeah,
the latter rather than the former. And I thought actually having to demonstrate that the government had done something wrong, or that the patients concerned had been subject to negligence, would simply create a long, drawn-out, costly process during which time many people would die, as was pointed out in that original letter that you drew to my attention a few moments ago.
Dr. Lowe, of course, referred to the small numbers in Scotland, relatively, 75 individuals, with the hint being that something could be done for that small group without impacting upon a wider claim on government finances. Was that something that was realistic? Could Scotland have gone its own way?
Well, it doesn't really matter whether it was a small number or a large number. The principle is the same, and the issue of whether it would have been possible. I mean, the fundamental, certainly my understanding at the time, and looking at the papers, it hasn't changed. The fundamental problem was the belief amongst some officials and some ministers that to do something in this area by way of compensation would create a precedent which would result in enormous liabilities falling on the health service, because it would effectively introduce some kind of no-fault entitlement to compensation. I didn't think that was the case, and now with the benefit of 30 years hindsight, it's hard to argue that that argument was sustained. I mean, I can't just remember the exact number, but the last time I think I read about this, I mean, the health service is spending something like $2 billion a year on cases where negligence has been proved. In this case, I didn't think that was a practical position. And at each stage in the argument, I mean, this went on, for 3 or 4 years, at each stage in the argument, where an attempt was placed to put a ring fence around particular groups, haemophiliacs or people who'd been infected with HIV from transfusions, in the end, and mainly, I would suggest, because of the strength of the public campaign, the logic of the position, which is set out in Mr. Lugden's note, became difficult to resist.
Do you remember how much discussion there was within the Scottish office? First of all, I take Mr. Lugden's note to be referring to Department of Health, the Treasury, etc., not just the Scottish office. But
Sorry.
Do you remember how much discussion there was within the Scottish office on this issue?
Well, I mean, our officials were in dialogue with officials in the Department of Health, and they were well aware of my views. I mean, there's at least one paper among the papers which you sent me where I suggested that we would not take the line to take that had been put forward, arguing that somehow haemophiliacs, because they had started with a life-threatening disease, were in a different category from people who had suffered from infection as a result of a transfusion. And I mean, the impact on their lives was exactly the same. And both had been infected as a result of medical treatment. The point about Mr. Lugden's note, which I seized upon as you read it, was that he acknowledged, and this is back in '87, that it would be difficult to distinguish the claim by haemophiliacs from claims of others. Well, I agreed with that, but my own view was that we shouldn't attempt to make that distinction. Sorry, your question was there much discussion? Well, I mean, I communicated what I thought as a minister, but at the end of the day, it was very much a matter of persuading the Department of Health to change their position, and to persuade the Treasury to agree, which happened some years down the line, I think when William Waldegrave became Secretary of State.
As Parliamentary Under-Secretary of State for Scotland, with all due respect to you and that position,
yeah,
you would not have been a position at that stage to make an impact on wider government policy. Is that fair?
Well, I mean, I did what I could, and didn't give up on the argument. But I thought the point that was made in that letter, that the numbers were small and that we could do something on our own, I didn't think that was practical because it required to take on this big argument about opening up the health service to making payments regardless of blame, which I understood that argument, which is why, as I said a few moments ago, which is why I thought the setting up of the Macfarlane Trust and we stopped talking about compensation and started talking about ex gratia payments, was the right line to take.
Your response to Dr. Lowe, or the letter that was drafted on your behalf and signed by you, is dated of October 1987. I'm not going to take you to it. It puts the government line, and is that collective responsibility kicking in? But regardless of what your personal views are, either you resign or you put the government line.
And it would hardly be sensible to resign if you were trying to change policy. The only way to change policy is from within. And I thought that very difficult, to work out what was going on in my head on the 6th of October, 1987. But I thought there was a degree of inevitability about the government having to change their position on this because it was so blatantly unfair. Now, in our letters, we expressed great sympathy for what had happened to those people who had been infected, but sympathy wasn't going to actually deal with the enormous impact that it had on those families, both financially and psychologically.
Just so that we have it on record, the reference to your letter is SCGV 607_047.
Can I just look at that letter, actually?
Yes, please. Let's bring that up. SCGV 607_047. Dated the 9th of October 1987.
Yeah. Can we go to the second page? Yeah. It's the last paragraph I want to see. Can't quite just see the last paragraph at the bottom of the page there. Thank you. Yeah, okay. I mean, I tried, I had to, there was a collective view on this. I tried to, insofar as I was able to change the letters, to indicate that we were not unfeeling as to the impact. And you'll see I've pointed out there that I didn't think that we could just make a provision for those infected with HIV who were haemophiliacs.
Just so that we have tied up all of them.
And you asked me earlier whether I knew him. I see from the letter that when I was on a hospital visit, I'd met him.
Just so we've covered all of the issues arising from this letter, the paragraph, the top paragraph of that page deals with the point about counselling, and the decision that had been arrived at and was communicated to Dr. Lowe was that counselling services would have to come from the budgets of the health boards, and you point out those budgets were nearly £1,600 million in the present financial year, and that there had been specific allocations to meet AIDS units in Edinburgh, Glasgow and Dundee. Why was it that you decided that the health boards should be the ones who were responsible for providing the counselling services?
Okay, so we allocated the money to the health boards, and they then had to fulfil their responsibilities, and in allocating the money, these were all taken into account. And we did set up some special AIDS units, but the only way in which we could find the money for doing special things was by reducing the overall allocation that was put to the health boards, and the health boards were there to actually judge their local circumstances. So there was a kind of, you just did not want to start, in effect, top slicing for particular areas, but rather you leave it to the health boards to work out what was needed in their own area and allocate the appropriate resources, or as much as you could afford given the settlement. Now, I did break with that on one occasion when a consultant came to see me to point out that we had no NMR scanners in Scotland, and that these could save the health service a lot of money, and that they could save patients a lot of distress who would otherwise have to have surgery. And I did actually say to officials, and the health boards themselves could not afford that expensive equipment, so we did top slice the budget and allocate the money for that purpose. But that was an exceptional thing, and any attempt, whether it was the health boards or whether it was education authorities, to make special allocations was very strongly resisted. Did it for Linlithgow Academy, where because Tam Daly, the MP, had made a very strong case because it was asbestos, but as a general rule, top slicing allocations or providing special funds was not considered to be sensible, because the moment you did it, you would have a queue of other people who could make a very strong case for why additional money should be provided for their particular purpose.
Did you as Minister have any informal way of putting pressure on the health boards to fund particular areas, such as counselling for AIDS?
Such as what?
Such as counselling for AIDS, which is Dr. Lowe's suggestion in the letter.
Well, we could make it clear that we thought counselling was important. We could put it in speeches, but I think everyone knew that. I mean, at that time, if a test showed you were HIV positive, I mean, that was a devastating thing, and people did need support. And I had no reason to believe that the health boards were not actually aware of their responsibilities in that respect.
The month after this exchange, the policy changed as a result of a decision made at a cabinet subcommittee. Your Secretary of State, Malcolm Rifkind, was present at that subcommittee. For the record, the reference is CABO 01000016_011. The decision was made that what became known as the Macfarlane Trust would be established. £10 million would be paid into it, and that would come from the contingency reserve of the Treasury. A question that I've been asked to put to you is, why was this a UK-wide scheme? And as an additional part of that question, did this fall within social security, a reserved matter for Westminster, or did it fall within health, or is that something of a red herring?
I think it's a complete red herring, and I think it would have been unacceptable to take the view that you would provide an ex gratia payment to one group of patients and not others in the United Kingdom. It had to be done on a United Kingdom basis, in all fairness. Well, in fairness.
Including the terms and the level of the recompense?
Oh, well, the level, I don't recall. Have I seen that paper that you've just referred to?
Yes, it was provided to you. We can bring it up on screen. Could we have CBO 01000016_011? They're the minutes of the Subcommittee on AIDS of the Home and Social Affairs Committee.
Okay, so where's the bit about the amount of compensation?
There is no discussion, save for the fact that the proposal is for £10 million.
Okay. And where had that proposal come from? Doesn't say. Had that been negotiated with the Chief Secretary, John Major, and the Secretary of State? Or?
So the Secretary of State for Social Services,
yeah,
and we can see there that's John Moore. Sorry, by this stage John Moore had become Secretary of State for Social Services. He put the paper forward, so there had been a change in his policy. Other papers that the inquiry has and evidence that it has is that Tony Newton, the Minister of State, was influential in that change of policy. He put the policy forward. It's page 11 of the document. No, sorry. Yes, that's right.
So is this at the time, this is John Moore, is he the Health Secretary as well as the Secretary of State for Social Services?
No, he's the Secretary of State for Social Services. The department has been...
so where's the Secretary of State for Health?
No, he's listed here as the Secretary of State for Social Services, but I think actually this is before the department was split.
Yeah.
Go back to the first page, please.
Yeah, well that's, I mean, hence your confusion and my confusion, because I mean, I don't see the Secretary of State. If it was separated, I don't. When is this? 90.
Exactly.
Yeah.
It is just at the point when the separation, I think, is about to take place.
Okay, so this is a proposal that's come from the Department of Health. Yeah. Yeah. Well, I mean, I have no recollection. I'm not sure we were even consulted on this 10 million figure, and I guess that must have been agreed between the Department of Health and the Treasury. But I'm guessing.
Well, certainly the Chief Secretary, John Major, was present and spoke in support of the proposition that the trust should be established.
Okay.
If we get to page 11.
Yeah, well, it's possible. There's nothing in the papers you provided me, and I have no recollection of being asked what appropriate level of compensation was. But I certainly would have been pleased that some progress had been made on the principle of actually making a payment and finding a way of doing it that got round the issue of creating an, as some people saw it, an unwelcome precedent.
Yeah. Can we just go back, please, to page 11 as was displayed a moment ago, because I think it may be the wrong page.
Yes, no, I'm afraid I was looking at the URN rather than the actual page.
So which page do you want us to look at?
Page 6.
Thank you.
We can see that the heading starting with Secretary of State for Social Services. That is where the Secretary of State, John Moore, introduces and speaks to a paper that he has prepared for the Cabinet Subcommittee, which is putting forward the proposition of £10 million being made in ex gratia payments. And then if we go along to page 8, please.
Okay, right. Well, there you are. It's there, isn't it? Sorry.
Just let's go back and take it more slowly. And what did you want to say, Lord Forsyth?
Oh, well, it's gone again.
You said, there you are, there it is, you said. And you
it's the bit, yeah. It's the bit where he explains why he's changed his mind. Yeah, here, yeah, yes. It's he had continued the policies of his predecessors in resisting special financial assistance for haemophiliacs infected by HIV on the ground that there had never been a general state scheme to compensate those who'd suffered adverse effects from medical treatment. However, he was now very clearly of the view that that position was not sustainable. Hallelujah. Yeah. I mean, what is the date of this?
That was the 10th of November, 1987.
Yeah. Okay, so that reflects what I thought at the time. However, there was then an agreement reached with the, I think, with the Haemophilia Society as to what the level of compensation should be. I think that's what happened. But I was not involved in that, except indicating, as I have done, what I thought the policy should be. So that was a step forward.
If we just go back to the first page, we can see you weren't present
No.
at that meeting.
I think I went to one, but I would only go if the Secretary of State was not, or in common with other junior ministers, I would only go if their Secretary of State was not available to go to a cabinet committee, which was kind of a three-line whip. Ministers were expected to turn up to cabinet committees. Secretaries of State were.
And we can see on this occasion, it was the Secretary of State, Malcolm Rifkind, who was present, and indeed the Secretary of State for Wales present there.
Yeah.
We can see that Dr. Mawini, the Parliamentary Under-Secretary of State for Northern Ireland, was also present, listed as also present, perhaps stepping in because the Secretary of State for Northern Ireland wasn't available. Would that be a fair inference?
Yeah, I don't see Wales. Oh, yes, Wales, Peter Walker was there. Gosh, that's going back. Yeah, Peter Walker, right.
Let's turn to a minute in which you were informed of this, again from Mr. Lugton, SCGV 40229_165. And this is dated the 13th of November 1987, so a few days later, and it is addressed to the Private Secretary of the Secretary of State and copied to you, and it refers to the announcement that is being made by the DHSS, so we can see the department hasn't at that stage been split, about this issue.
Yeah.
And then if we look at paragraph 2, now, this is replying to a minute at the 11th of November from you, which we haven't been able to identify. But this is what is said in reply. In his minute of the 11th of November, the Private Secretary for Mr. Forsyth recorded Mr. Forsyth's inquiry as to how the proposal for a grant would help with the problem of mortgage protection policies, etc. The existence of a trust fund will not, of course, make it easier for infected haemophiliacs to obtain life assurance cover or mortgage protection, because they will remain, in the view of the life insurance companies, uninsurable risks. But the fund will ensure that there is some financial support for those who, because of the combination of their haemophilia and their HIV infection, find themselves in extreme financial difficulties. There may be pressure in due course for further financial support from the government of haemophiliacs. But for the present, it seems that the Haemophilia Society have gratefully accepted the not insubstantial sum which the government are making available. Now, very difficult after all this time, but do you know what had triggered your minute and your raising the issue of the difficulties of mortgage protection policies?
Well, I thought, I mean, if you looked at the position, if just imagine what it must have been like. For the people who were infected. I mean, their whole lives were turned upside down. They were probably facing the possibility of an unpleasant death. Their position financially and also within society at that time was difficult, and I mean, I suppose that it was code really for, well, it wasn't code, it was just saying, well, fine, they've agreed to this amount, but it doesn't really deal with the enormous dislocation that is being created in their lives. You know, if you can't get a mortgage, if you can't get life insurance, if you can't make provision for their families.
Do you want to take a moment?
No, I'm fine. Sorry, it's quite. I mean, it was quite an emotional thing at the time, and this wasn't a just a normal policy decision. It was about not that I think there was fault, but it was about trying to make what was possible amends for what had happened.
Do you think the sympathy and the concern that you felt on this issue was shared by others within the Scottish office, both at a ministerial and civil service level?
I didn't. Yes, I think it was, but I mean, I thought it was my job as a minister to communicate what I felt about it, and I wasn't aware of any pushback. There was the practical issues of how do you persuade the Treasury and those colleagues who were worried about precedents to go as far as I and others would have wanted, and you weren't going to achieve that by making an argument that was not sustainable, and which did not recognise that there were financial pressures at that time. But to my mind, at that time and subsequently, too much of the argument about who should be included and what the level of compensation should be was looking at the cost rather than the impact on the individuals concerned.
Let's come forward in time to November 1989, which is the point at which an extension of the McFarlane Trust was announced. Initially £19 million, later rising to £24 million to allow lump sum payments as well as the ex gratia payments. That was a decision that was taken by the Secretary of State for Health, Kenneth Clarke, and the Prime Minister, Margaret Thatcher, at the time. And I'd just like to look at the way in which the Scottish Office was involved or was not involved. If we could have on screen, please, SCGV 40230_145. This is a minute which is dated the 1st of February 1990, and it's sent by Mr. Tucker. It's sent to your private secretary and copied to the private secretary, Secretary of State, Parliamentary Under Secretary of State, the Permanent Secretary, and others. What the minute states is this: McFarlane Trust ex gratia payments to haemophiliacs with the AIDS virus. This minute is to advise Mr. Forsyth of a request from the Treasury for a contribution towards the additional monies which the government have agreed to pay for the McFarlane Trust, and to seek his views on whether a payment should be made, in which case it would have to be found from the existing 1990 to 1991 allocation of funds to the central services agencies. Background. I won't read through all of this, but I will summarise the relevant parts. The first point is that the Secretary of State for Health announced on the 23rd of November the additional ex gratia payment of £19 million. As I've said, that later rises. Paragraph 3, it says the decision to increase the trust monies by £19 million was taken without any prior consultation and agreement with the other health departments, and it was assumed, therefore, at the time of the announcement, of the decision by Mr. Clarke, that the monies would be provided from the Treasury. In a letter dated the 23rd of November from Mr. Clarke to Mr. Lamont, then the Chief Secretary, he indicated that he would be expecting territorial departments to make the usual contribution. We consulted the other departments at official level, who at that time were indicating that they would resist payment. The Treasury have now asked for a payment of £840,000 as our share of the additional payment. The Treasury has indicated that it will accept payment in either this or in the next financial year. Paragraph 4 states that the Financial Division have advised that no funds were available in the current financial year, and then there is some discussion about how the funds could be found. We can go to paragraph 6 on the second page. Tucker wrote, there can be no question of Scottish haemophiliacs of HIV not benefiting from the trust, and thus arguably we have a moral obligation to make a contribution. He then talks about the discussions that had taken place with the Northern Ireland office and the Welsh office. Then paragraph 7, we have the observation that if Mr. Forsyth agrees, we suggest therefore that the Scottish office contribution should be made a priority for payment in the next financial year from within the existing CSA-PES provision, although this is likely to result in representations from Mr. McQuaker, and then an expectation that you would wish to discuss this matter with the Chief Executive. I take that to mean the Chief Executive of the Common Services Agency. And if we look at your reply at SCGB 40230_143, sent to Mr. Tucker and copied to the same distribution list. Your private secretary writes this: Mr. Forsyth has seen your minutes of the 1st of February 1990 and is of the belief that we will clearly need to make our appropriate financial contribution. He is, however, somewhat surprised that this issue was not marked up for his attention, even tentatively, during PES discussion. There are a number of other internal documents from around this period which you refer to at paragraph 65 of your statement. But in short, should we understand that the decision that was made to expand the McFarlane Trust was one that was taken without any prior consultation with you or with the Scottish office more widely?
Yes, and I was extremely irritated because my understanding had been that it was recognised that this was a wholly exceptional event that had occurred, and that and I think at an earlier stage in the documents there's a reference that, you know, we were looking to the contingency fund to meet the cost, and I thought it was penny pinching on the part of the Treasury to try and rake back some of that cost from the health budgets. But it could have been that I was mistaken in that belief. But it seemed to me that just as we had to recognise this was it was exceptional, it should have been met from the contingency fund. That is what I thought the contingency fund was for. But we did want these payments to be made, and it was a step forward, and I was certainly irritated by it, and I was irritated that we had not been engaged in the discussion as to both the quantity and the means by which it would be funded.
In Mr. Binney's minute, your private secretary's minute, it's recorded that you were somewhat surprised that the issue was not marked up for your attention during the PES discussion. Was that surprise at Scottish office officials or surprise at the way that this had been conducted in Westminster?
To be honest, I mean, it's his words, not mine. If you pressed me as to what I thought it meant, I'd say it was in Westminster, but I honestly don't recall. It was probably just I was grumpy that we were being asked to provide money which we were not expecting to provide, because I thought it should come from the contingency, and that may have been David Binney, who was an absolutely outstanding private secretary. May have been his interpretation of it. I mean, I did appreciate that, you know, public expenditure was very tight at that time, and I did understand the reasoning. I think the advice from officials that we couldn't hold out, given that the other territorial departments had gone along with it, and I didn't want to damage our ability to influence further changes in our policy on this matter.
If we could have on screen SC GV 40230_122. There was a series of internal minutes about how the funding situation was going to be met. This is from the 13th of February 1990, at the conclusion of that series. It's sent to your private secretary by Mr. Tucker.
Oh, yeah, well, that's helpful, yeah. I mean, that makes the point, doesn't it? They didn't know that he was going to change his position, and the previous grant was taken from the contingency reserve, which is probably why I was under the impression that that's what was going to happen.
So the fault, if fault there was, lay with Westminster and not with the Scottish Office officials.
Well, I don't know. I wouldn't blame all of Westminster. I think the fault here lay with the Treasury, who decided, well, we're not going to use the contingency fund. We'll make the territorials and the Department of Health find the cash. And with the Department of Health in agreeing to that, I'm bound to say if I'd been the Secretary of State for Health, I would have insisted on it coming from the contingency fund and argued very strongly for it. He may very well have done so, but we were not involved in that dialogue.
If we look at the second paragraph, the Finance Division has today informed me that in the course of technical discussions which they have been having with the Treasury as part of the process of scrutiny of main estimates, it has been possible to earmark resources to cover the contribution required from Scotland of £840,000.
I think that's I think that is civil service speak for we found the money down the back of the sofa. Yeah.
Let's turn now then to financial support for the settlement of the HIV litigation. Again, a number of references in your statement at paragraph 66 to this. We know from other evidence that the inquiry has heard that on the 11th of December 1990, the Prime Minister, by that time John Major, and the Secretary of State for Health, by that time Mr. Waldegrave, announced the proposed settlement of the HIV litigation in England and Wales. Now, the Scottish position is set out in a minute sent by Mr. Tucker on the 15th of January 1991. If we could have on screen, please, SCGV 40231_019. This was sent on the 15th of January 1991 to the Secretary of State's private office and also by the stage you were Minister of State, sent to your private office as well as the Under Secretary of State and various others. The background to the announcement is set out, and the English position is set out on the first page. If we turn to the second page, please. The Scottish position, what Mr. Tucker wrote at paragraph 6 is this. Unlike their English counterparts, the Scottish solicitors have not carried out any informal soundings, chiefly because they have not been involved in the negotiation process at all, and they have no material on which they can carry out any such soundings, other than the public statements by ministers. Scottish solicitors were not involved in the English Steering Committee's consultation procedure. So far as they and their clients are concerned, the government's offer to settle is an offer made by the government out of the blue. The Scottish solicitors made no initial approach to central government, whereas the English Steering Committee did. Our legal advisors have indicated that one of the consequences of this is that the offer of settlement in Scottish cases will have to take a slightly different form. In any event, the terms of the English settlement are inappropriate for Scotland. Draft proposals for Scotland have, however, now been drawn up by the Solicitor's Office, and we will propose to let the Scottish solicitors have sight of this in the next day or so. He goes on to comment about how Scottish solicitors have asked for a period of 6 months to investigate the claims fully, and Mr. Tucker's recommendation on behalf of him and his colleagues was a period of 3 months. This is at paragraph 7. He says to minimise criticism but we're being asked to agree to a settlement without being afforded time to assess its value. In paragraph 9, the conclusions, Mr. Tucker, sorry, this is on page 3. Mr. Tucker wrote, in view of the prospect that the majority of English patients are now likely to accept the settlement, the Department of Health will not wish to delay the their timetable for acceptance. But the numbers of litigants in Scotland are so small that even if they all refuse, it is doubtful that this would cause the offer to be withdrawn. We consider that in the special circumstances of the Scottish position, that some flexibility in the timescale for acceptance should be given. This need not cause any embarrassment to the Department of Health, since it was always possible that a claimant could refuse the offer and pursue the matter through the courts, even if legal aid were not to be available for this. We understand that Northern Ireland is broadly in a similar position to us in relation to the processing of their few draft claims, when a draft letter is put forward and to be sent to Mr. Waldegrave. First of all, should the Scottish office have been consulted prior to the announcement of a proposed settlement in December 1990?
Yes, of course it should have been. I mean, can I just see the beginning of the page 1 of that document of the 15th of January? Yeah, I mean, it's addressed to the Secretary of State. It's not addressed to me. I would have been furious at the discourtesy and the non-involvement of the Scottish office in what was a very sudden change of position on the part of the Department of Health, whilst at the same time being pleased that they had made that change of position, but pretty angry that they'd not taken account of Scottish circumstances, and in particular the position of the Scottish plaintiffs. So, I mean, it's not a very good. It doesn't make very good reading in terms of the way in which government should have been operating with the devolved administrations.
We have heard in other evidence the importance that was attached by Mr. Waldegrave and Mr. Major to the fact that the offer in England and Wales came from the plaintiff's side rather than the government side. In Scotland, would you agree that the position was going to be reversed? That
yes.
The offer would be made by the government.
Yeah, but that is not an excuse for not involving, as far as I'm aware anyway, the Secretary of State or ministers and our officials on what was being proposed in a timely manner, which would enable us to deal with this effectively and efficiently.
The relatively, we can see from, I won't go through all of the correspondence that follows, but there is a degree of flexibility shown by the Department of Health about the timescale involved for Scotland, but no flexibility in terms of the overall terms of the settlement that are being offered and the amount of money that will be offered in each category. In effect, the Scottish plaintiffs were being told,
take it or leave it, yeah.
Yours to accept, yeah. Given
and actually, well, you're a lawyer and a barrister, pretty difficult negotiation to carry out from the point of view of the Scottish litigants.
We can see from Mr. Tucker's minute as well that many of the Scottish cases were at a relatively early stage, and so there hadn't been a full degree of investigation. So another disadvantage there for the Scottish plaintiffs. Yeah,
I mean, it was good news that the Department of Health had finally, as I would see it, seen the light on this. But the precipitative way in which it was done left us kind of a bit exposed.
It may be suggested that the offer, the settlement, was in effect imposed upon Scottish plaintiffs, Scottish litigants. Do you think that would be a fair characteristic?
I don't know. I wasn't involved in the discussions. I guess. I mean, I'm purely speculating, but I guess the Scottish litigants would probably have shared my view. Well, at least we're making some progress on this. I don't know. I can't speculate.
As a matter of inquiry, Mr. Hill, were the Scottish actually plaintiffs, or were they pursuers in the Court of Session?
That is a matter that I will turn to others to assist me with over the break and get back to you.
Because Scotland had a completely separate legal system, did it not? And therefore one might have thought that the same issues could be raised before the Court of Session by pursuers and not as joining in with plaintiffs in a different jurisdiction in England. But
they were certainly treated as separate, a separate jurisdiction and a separate set of claims. And we saw from Mr. Tucker's minutes that there were certain aspects of the settlement, not the overall financial aspects, but other aspects of the settlement, which would have to be bespoke to the Scottish system and couldn't simply be transferred across from the English and Welsh system.
Yes, so that all suggests that there was separate litigation being conducted in Scotland, and they were therefore technically, I think, to be called pursuers rather than plaintiffs, which is an English expression. You're agreeing, I think.
Yeah. I mean, I'm not a lawyer. I mean, but I accept. There was a lack of respect for the fact that these claims were being pursued under the Scottish system, and it seemed to me all I wanted was for this to be settled as quickly as possible. And because my understanding was there was a Scottish process, there was a real risk that the Scottish haemophiliacs who've been infected would have to wait longer for the payments to which they were entitled. That would have been my concern at the time.
So I'm grateful to Mr. Dawson, who represents many of the Scottish Court participants, for confirmation that the litigants that we're discussing were pursuers, and these were separate actions in Scotland. I don't think that there is any doubt about that whatsoever.
So it was technically a different action. They weren't members of the same class in respect of which there was settlement in England. So the question about coordination is coordination on litigation on the same topic, raising the same issues by and large, but in two separate jurisdictions.
Yes, the only
and with obvious knock-on effects from the one to the other, which made it all rather more complex. Yes, I see.
Yes, there would have been obviously a different factual matrix in Scotland for some of the cases compared to England and Wales, not least because of the different roles of BPL and PFC. But they were separate actions, yes.
Yes.
Can we go, please, to SCGV 40231_017? This is your response, as communicated by David Binney, your private secretary, to the minute Mr. Tucker sent, we can see the copy to the sent to the private secretary of the Secretary of State and copied to others. It says, Mr. Forsyth has seen Mr. Tucker's minutes of the 15th of January 1991 to you and would like to recall that he is content with reactions suggested by Mr. Tucker. Mr. Forsyth is, however, concerned that compensation does not apply to others who have been infected by HIV through deficient blood products, but who are not haemophiliacs, e.g. people suffering from leukemia who have received transfusion. Just so that we are clear on the meaning of that second paragraph, the concern that you're expressing there is that, in your view, the level of compensation or ex gratia payments should be extended to those infected through blood transfusions and such like, and not that you are concerned that it would be.
Yeah, I mean, is it not obvious that that's what it means? That
I think read on its own, it would be open to either interpretation, but read in the context of the other documents that we're going to look at.
Yeah, the struggle continued. We'd made some progress, but an attempt was being made to form a distinction, not just for people who'd leukemia, but anybody who'd had a transfusion or a transplant or anything of that kind. I could not understand how it was possible to argue. Perhaps compensation was the wrong word. Perhaps it was a payment, an ex gratia payment. How it was possible to argue to exclude them, other than on the grounds that you wanted to save the cost.
In terms of the battle continuing, as you put it, let's have a look at DHSC 302840_017.
By the way, when I'm talking about the battle, I'm not referring to me. I was just a junior minister, but to the outside campaigns which were going on, which were very effective, and as far as I was concerned, welcome. And informally, I had some contact with some of the MPs who put down early demotions in Parliament and so on. I think this is 1991. I'm not sure on the timetable, but there was a great deal of public concern about the extent to which compensation or payments were limited, both as to value and as to extent.
If we could just look at, forgive me for 1 second. We're looking here at a minute that was sent by your assistant private secretary, Derek Beerhoff, to Mr. Tucker. It's dated the 29th of January 1990. The reason I was pausing there is I think that might have been an error for 1991. But it says here, Mr. Forsyth has seen the draft reply for him to send to Alan Stewart concerning the extension of ex gratia payments to those people who have contracted the HIV virus as a result of a blood transfusion. Mr. Forsyth would be grateful if you could give consideration to the extension of the scheme to include people infected in this way. I would appreciate if you could provide a note and a revised draft in due course. Alan Stewart was, I believe, a member of Parliament.
He was a member for Eastwood, and I can't just remember whether he was a minister at that time or not.
Forgive me, it's my error, and I've taken this out of sequence. This is the 29th of January 1990, and we will see that the reply from Mr. Tucker is the 6th of February 1990. So this is before the sequence of events that we have just discussed, which...
That would explain my comments. because saying that we should look at that. I mean, I was pressing officials. I don't. Again, I'm relying on my memory, but I don't recall having to press them very hard. I think there was an understanding that it was very difficult to hold the line. There is somewhere in the papers another comment from me where I've asked them not to include a line to take, which sought to make, I think, a completely illogical distinction between people who've been affected who were haemophiliacs and those who are not. It was, completely untenable line. I couldn't.
That is it. Sorry, let's bring DHS.
Finish. Can you let Forsyth finish?
I couldn't change the collective policy, but I could, in my letters, give an indication of or a hint of what my personal view was.
DHSC 302840_018 is, I think, the document you're referring to. And this is the reply to your previous minute from Mr. Tucker, providing the note on this topic.
The date of that is what?
It's the 6th of February 1990.
Okay, so that's just after that Alan Stewart thing, yeah.
And it refers expressly back to the minute of the 29th of January that we've just looked at. It provides some background about the McFarlane Trust being set up in 1987 and the campaign of Robin Cook and Claire Short in particular to extend payments to those who had contracted HIV and AIDS as a result of blood transfusion. Mr. Tucker says that this was resisted on the grounds that haemophiliacs differ from recipients of blood transfusion in the following ways. A, they were already suffering from a serious disability which affected their employment, mortgage and insurance prospects. And B, the hereditary nature of haemophilia can, and in some cases does, mean that more than one member of the family may be affected. And that we can see some marginalia if we expand.
Yeah, this is an example of right at the beginning, Mr. Chairman, right at the beginning when I was complaining about not getting the documents which I had marked up, and you can see there, and I've written, these arguments do not stand up if they're already disadvantaged, vis-a-vis negligence, etc., then those people who are HIV positive following blood transfusions are more disadvantaged. Now, I don't know if that's putting it too crudely, but I just thought that arguing that because haemophiliacs were already suffering from a serious disability which affected their employment, mortgage and insurance prospects, arguing people who one moment were able to get employment or their employment was not at risk, remembering the timing of all of this, and could get a mortgage and insurance, and then suddenly found that they were HIV positive as a result of a transfusion, that somehow they were less disadvantaged, was an utterly ridiculous argument, and I tried to erase it from the standard reply explaining the collective position of the government at that time.
Just so we're clear,
I see that my writing has not improved.
We can see for those who need it, DHSC 302839_015 is a minute where those words are typed up by Mr. Bierhoff,
right,
sent to Tucker and others.
And the second point on the hereditary nature of haemophilia can affect other members of the family. Again, I didn't see that as relevant. I mean, people where perhaps the main wage earner was suddenly HIV positive, I mean, their families were just as affected. So that is not to say that those people who had haemophilia were in a very distressing position, who had been infected. I just thought they were trying to draw a line that was just completely unsustainable and indefensible. And people like Robin Cook, Claire Short, and others, were arguing that very, very persuasively in the public sphere.
Just so we're clear on the chronology, because of my error, this was a view that you were expressing in February 1990.
Yeah.
We know from other evidence that we've heard that the policy in terms of extending payments to patients infected through blood transfusions and other means wasn't changed until Mr. Waldegrave made proposals in December 1991.
Yeah.
And the announcement of the change in policy was made in February 1992.
Yeah.
Do you recall how much of a role you had in the discussions that took place leading to that change?
By William Waldegrave, you mean?
Yes, or ultimately the change in policy by the government as a whole.
William Waldegrave took that decision, and as far as I was aware, we weren't consulted. And I mean, you've already touched on the problems that caused us because it came out of the blue.
That's a slightly my fault. That was an earlier decision to settle the HIV litigation was just about people with haemophilia.
Oh, I see.
The question extending the payments to those with blood transfusion that came about because of a change in policy by Mr. Waldegrave in December 1991, and then was announced in February 1992. My question is a general one. Do you remember how much of a role you had in discussions that led to that change?
In 1992?
Yes.
When was it in 1992?
It couldn't have been 1992 because the announcement was made in 91.
Yeah, and also I think I was...
whether you were discussed with Mr. Waldegrave or others leading up to his announcement. In other words, do you think have any influence over the announcement?
Yeah,
that
I think by 1992 I was in the Department of Employment, but I may be wrong. No, I wasn't involved in those discussions. And as far as I can see, looking at the papers, our officials weren't involved in those discussions. And unless I'm getting confused as to chronology, the problem that we've just discussed about the plaintiffs in Scotland arose because there had been this sudden change in the Department of Health's position. I wasn't going to complain about that particularly, but we were irritated that we'd not been engaged in the discussion.
I think what you've been asked about, just to be clear, and Mr. Hill will correct me if I'm wrong, is two separate issues where the government may have did change its approach. The first in respect of settling the litigation in England, which had implications obviously for ongoing litigation in Scotland. The second is the question of extending the McFarlane Trust type of compensation to those who did not have haemophilia but were infected because of their treatment otherwise through the NHS.
Yeah, and I've got no recollection of the Department of Health engaging with me or on that issue, although I would have expected officials to have communicated what the view of Scottish ministers was, which was clearly set out over and over again, but particularly I mean, the minute that we're looking at now, the 29th of January, I mean, it couldn't be clearer.
Yes.
Does that help?
I hope that does. Mr. Hill, does that help you?
Yeah, yes, it does. It does. And that concludes my questioning on that area.
Well, that's then a very neat point at which to take a break for lunch, and we can come back on 2:05. 2:05.